You're going to talk about the recent Hobby Lobby decision, aren't you?
Right. Taking a little break from the failures. And, we watch Supreme Court decisions, especially when they involve church-state separation issues. Mm-hmm. There's been two in recent memory. One is the Greece case, Greece, New York, with public prayer at city council meetings and that sort of thing, and the Supreme Court got that wrong.
Yeah,
I have to say.
Jen and I talked about that one shortly after it came out.
Good. And the more recent one was the Hobby Lobby decision, which I want to talk about today. And some background: you need to know about two different laws that were passed. One is the Religious Freedom Restoration Act. Boo! It passed by Congress in 1993, quite old. It requires the government not to substantially interfere with an individual's free exercise of religion, whether compelled by the religion or whether it's part of the core religious tenets or not. And it was major sections of it were constitutionally upheld by the Supreme Court in 2006, and it applies only to federal law, although a lot of states have made their own RFRA acts, and Texas is one of those. The other thing to know about is the Affordable Care Act, or Obamacare, which allows the government to specify what kinds of preventative health care must be covered by employers' health care plans. And this includes contraceptives. So those two things kind of came into a collision with each other. And in particular, there's specific contraceptives that are of interest. Hobby Lobby and Conestoga Wood Specialties, which were the two litigants, they are religious owners of businesses that consider some contraceptives to be abortifacients as they block implantation of a fertilized egg. And this includes Plan B sorts of drugs and IUDs. But note that between 60 and 80% of naturally fertilized eggs don't implant anyway. Mm-hmm. And this view that these are abortifacients is not shared by the medical community. It's as abortion is the termination of a pregnancy, but the pregnancy hadn't begun yet because implantation is required for pregnancy to begin. So the medical this view is not supported by the medical community. It's just kind of their own fiction.
Yeah. So already right off the bat, we have the situation where there's a corporation that is claiming because its owners have this religious opinion that contradicts scientific fact, that their religious opinion extends to be the corporation's religious opinion. Does the corporation have her favorite fucking ice cream too?
Right. And is also protected by the First Amendment and RFRA.
And then moves on down the road.
Yeah.
After that.
Yeah.
So continuing.
So the conflict, these private businesses sued in federal court not to have to comply with the Affordable Care Act in this limited area, citing that it conflicted with their free exercise religion as covered by RFRA. And if they don't comply, they could be subject to a $2,000 per employee fine for not providing such coverage. So that's the tension. And the decision, which happened on June 30th, the Supreme Court ruled 5-4 that closely held corporations with religious objections should not be held to the Affordable Act rule in this case, as the enforcement was not the least restrictive means of implementing the government's interest.
Which is a weird interpretation of the law.
Well, no, it actually is. What's strange about this is that they actually ended up ruling whether this was the ACA was compatible with RFRA, not necessarily RFRA's constitutionality, which there's actually Supreme Court briefs or amicus briefs that say it's not.
So
right? They ruled on a rather limited thing.
I may be wrong, but the language that they used here was least restrictive, which means that there seems to be an onus for the government to take the least restrictive.
Yes.
And instead, I thought it was the way that RFRA was stated was that it should not be unduly.
No, it's the least restrictive. And so this
oh my gosh, the least restrictive could be defined as 0.
Oh yeah, absolutely.
Well, aren't we clever?
So Ruth Bader Ginsburg offered a scathing dissenting opinion, which I think is worth reading and is a very well done thing. The majority decision, I think, was wrong here. Justices voting in favor of the opinion are Catholic. Five of the 6 justices who are Catholic voted for it. Alito, Roberts, Scalia, Kennedy, and Thomas. All of the female justices dissented, Ginsburg, Kagan, and Sotomayor. So that's kind of interesting.
So wait, you're telling me the people whose religious beliefs oppose contraception ruled unanimously or nearly unanimously in favor of the corporation that was opposed to providing contraception, and the women who would have benefited from the contraception unanimously dissented? Well, that sounds like the law has been interpreted correctly by all, doesn't it?
I guess so. Yeah, I found that breakdown rather interesting because it just did seem to be along party lines or whatever.
It's a good thing we weren't having racism back on trial.
Right.
Not enough black justices to get that to go through.
Right.
Well, we're back to slavery.
So conservatives hail this as a win for religious freedom, although corporations aren't people and don't have religious beliefs needing constitutional protection. The U.S. government did fail to meet the burden of strict scrutiny, as in the case as required by RFRA, which is a bogus law in my opinion. On the other hand, Hobby Lobby's owners' religious practices were not substantially burdened, in my opinion, by following the ACA, the Affordable Care Act. So other people, besides religious conservatives, are concerned that, A, corporations are getting more rights never envisioned by the framer with no corresponding responsibilities. So here you have a case of, oh, I own a company and I've shielded myself from the financial fallout from this company going down or whatever, but I'm going to imbue it with my religion, and it's like having your cake and eating it too. So that's no good. And what's going to happen, I think, here is that the religious rights of the powerful will take precedence over the religious rights of individuals, such as the employees in this case. And the government have to make up the difference, or third parties will have to make up the difference. And that's definitely problematic. So we're also concerned that religious corporations and powerful individuals can work the system to subvert any law. So there's a couple ironies here. One is Hobby Lobby's 401k plan holds assets in companies making those very same contraceptives they claim to have religious qualms about. Oops. They didn't check into that, and apparently it was a late decision. And they even covered these same contraceptions before the ACA was passed. So this seems to be a political fight of some sort.
Wait, are you telling me that Hobby Lobby used to provide insurance that covered this?
Yes.
And then when they were told they had to, they decided they don't want to?
Yeah.
Wow.
Yeah, so there's some irony. Another irony is that this whole chain of events harkens back to a Supreme Court case back in 1990 where you had some folks that some Indian Native Americans who wanted to smoke peyote, and that was going against the laws of whatever state they were in. And the Supreme Court ruled back then that challenging that a person may not defy natural laws of general applicability even as an expression of their religious belief. And this is what caused RFRA to be passed by the Senate and House at that time, the legislature, and it was a near unanimous thing. But during the Supreme Court ruling then, this is a really choice quote, Justice Scalia said, to permit this would make the professed doctrines of religious belief superior to the law of the land and in effect permit every citizen to become a law unto himself. So that's an interesting money quote. So
he is the most brilliant idiot I've ever heard of. Yeah. I mean, I'll give it to him.
Right. So the ruling back then was a good one, and even Scalia had it right back then. And the RFRA kind of does an run around the Constitution, in that it broadens this religious rights, so it doesn't even have to be part of your core tenets or anything. It's just anything you want to claim as a religious belief.
And some of the objections, I don't know if it's specific to the foundation of RFRA, were things like, as they make decisions about what you can and can't do on behalf of your religion that may violate the law, there were people who were concerned that this was going to go too far with the government intervening, so that, for example, you wouldn't be able to bite the foreskin off of babies.
Sure.
We need to desperately protect the right of people to give babies syphilis, and so we need to put that under
herpes, right?
Under free speech or under religious protection. So that's why we need things like
this is a Pandora's box as far as I'm concerned.
Religious Freedom Restoration
So
Act.
what about this religious beliefs? Well, if religious beliefs need not be based on a fact, a holy book, or a core tenet of a religion, or even the shared beliefs of a church, or even limited to theological claims, it can be anything at all. So you can cook up whatever religious belief you want and have it trump whatever laws. And this RFRA has become a kind of a bulwark of laws. There's another law called the Religious Land Use and Institutionalized Person Act, which kind of expand the scope of these things, and many state and federal laws, many states and local laws are also expanded by local and state laws that are doing this some sort of thing, including Texas. And Ruth Bader Ginsburg said in her dissent that the wisdom of Congress's judgment on this matter is not our concern. It was outside of the scope of what they ruled on, unfortunately, because this RFRA should be struck down as far as I'm concerned.
You know, it's my sincere religious conviction that Supreme Court rulings cause autism, and I don't want my tax dollars going to support the Supreme Court anymore.
Apparently, all these laws carefully carve out taxes as being the subject of them. It's very interesting. So who benefits? Well, the only people who are really going to benefit are the ones with the money to sue to get their religious beliefs put into, to trump whatever law is in there. So the wealthy, many churches who have amassed a lot of tax-free wealth are going to be able to do this, and religious corporations like Hobby Lobby and such. But religious minorities and most individuals are going to be screwed by this, and it's really kind of a Pandora's box. So what I'd like to see out of this is religious minorities running this thing amok so that hopefully it gets addressed and everybody can see that, hey, we can't put religion above the law. So I'd like to see same-sex couples, for example, using RFRA to demand marriage licenses in states that don't recognize them. Perfectly appropriate as far as I can tell. Women seeking abortions can use RFRA to sidestep the recent restrictions in abortion laws.
The government is certainly not going out of its way to have the least restrictive path to get an abortion. Mm-hmm. They're going out of their way to make it as restrictive as possible.
Absolutely.
And so if we just claim that it's a sincere religious conviction that one should have a moral and legal right to an abortion.
And a lot of these, minority or biblical beliefs have been brought up as like, is this going to allow the promotion of slavery, or Jehovah's Witnesses not to cover transfusions, or Christian Scientists not to have health care at all.
And to be fair, what Don's talking about here is not necessarily this specific Supreme Court decision, which they did rule narrowly on that it was only about this.
They pretended to rule narrowly on, but I don't think
there's the possibility of expansion.
Yes,
pointing back to RFRA.
Yeah, well, they said it's a narrow thing, and they tried to limit the scope, but I just don't see that happening. So, Let's worry more about the religious liberties of minorities, and let's worry more about the religious liberties of individuals rather than of corporations and that sorts of things. So, did you have anything else? Because I'm pretty much done.
I think I interjected plenty.
Okay. And if we have any calls on that, that'd be a wonderful thing to call in on.
Well, there's one right off the bat.